Welcome to Chapter 6, Data Processing Framework for Vulnerable Populations. We explore the framework and responsibilities of data fiduciaries and the rights of these individuals. In today's digital age, the protection of personal data, particularly for vulnerable populations, has become a key priority. Vulnerable populations, including children, individuals with disabilities, the elderly, and marginalized groups, often face heightened risks when their personal data is processed. These individuals may have limited capacity to understand the complexities of data processing, leaving them more susceptible to exploitation or harm. The Digital Personal Data Protection Act, 2023, DPDP Act, recognizes these concerns and introduces specific frameworks to ensure that data processing activities related to vulnerable populations are carried out with utmost care and responsibility. This chapter will delve into the provisions within the DPDP Act designed to protect the personal data of these groups, outlining the obligations of data fiduciaries and the rights these vulnerable individuals hold. Understanding vulnerable populations. Vulnerable populations are groups that, due to their social, economic, or physical conditions, are more likely to suffer adverse consequences from the processing or misuse of their personal data. These groups often have limited understanding of data processing practices and face increased risks when their personal data is mishandled. The following groups are classified as vulnerable populations under the DPDP Act. Children, individuals under the age of 18. Children's data is particularly sensitive, as they may not fully agree implications of sharing their personal information. Individuals with disabilities. This group includes people with physical, cognitive, or mental impairments who may find it difficult to manage or understand their data privacy rights. Elderly individuals, older adults who may be more vulnerable to data exploitation, especially when it concerns health or financial data. Marginalized communities, socially or economically disadvantaged groups that may not have access to legal recourse or the ability to protect their data rights. Data protection principles for vulnerable populations. The DPDP Act introduces provisions that require data fiduciaries to apply heightened protections when processing data from vulnerable populations. These protections ensure that the data is handled with extra care to prevent misuse and exploitation. Principle of enhanced safeguards. The DPDP Act mandates enhanced safeguards for vulnerable populations, recognizing their heightened risks. Data fiduciaries must ensure that personal data is processed transparently and securely, while respecting the rights of individuals, especially in relation to informed consent, purpose limitation, and data minimization. 1. Informed consent. Consent is a fundamental requirement under the DPDP Act, and for vulnerable populations, it becomes even more critical. For children, consent must be obtained from a parent or legal guardian, ensuring that an informed adult is aware of the data collection and processing consequences before agreeing to share sensitive data. Example: a children's educational platform must obtain verifiable parental consent before collecting data such as the child's name, age, and educational history. For individuals with disabilities, data fiduciaries must ensure that consent mechanisms are accessible. This includes providing alternative formats for consent, such as audio or braille, or offering assistance where needed. Example: a service provider should ensure that people with visual or hearing impairments are provided with the necessary tools, such as text-to-speech or sign language assistance, to fully understand and give informed consent. Purpose limitation. Data collected from vulnerable populations must only be used for specific, lawful purposes, and should not be processed for any other reason unless explicitly agreed upon by the data principal or their guardian. Example: a healthcare app collecting data from children should limit its use to healthcare-related services only, ensuring that the data is not used for non-medical purposes, such as targeted marketing. Data minimization. Data fiduciaries are required to only collect the minimum necessary data needed to fulfill the intended purpose. This is particularly crucial when dealing with sensitive data related to vulnerable populations. Example: a social media platform targeting children should limit data collection to the basics needed to create a profile, such as a username, and should avoid collecting more sensitive information like location or personal preferences unless essential. Specific provisions for children's data. The DPDP Act has clear provisions to ensure that children's data is handled with the highest level of protection, acknowledging their vulnerability and limited capacity to consent. Obtaining parental or guardian consent, Section 9. For children under 18, parental or guardian consent must be obtained before processing their personal data. This provision ensures that children's data is only processed when there is adequate oversight by an informed adult. Example: a children's e-learning platform must obtain verifiable consent from the parents before collecting personal information, such as the child's name and age. Exclusion of harmful data processing. The DPDP Act prohibits the collection of personal data from children if the processing may lead to harm, especially in situations like targeted advertising or profiling. Example: a children's gaming app must ensure that no data is collected that could be used to target children with advertisements for products or services that are unsuitable for their age. Specific restrictions on children's data. Targeted advertising. The DPDP Act prohibits the use of children's data for targeted advertising. Example: platforms that target children cannot collect their interests or preferences for the purpose of personalized ads. Data retention. The DPDP Act emphasizes that children's data should only be retained for as long as necessary and deleted when no longer needed. Example: a children's education app should delete the child's personal data once they graduate or cease using the platform. Data protection for vulnerable adults. Handling data of individuals with disabilities, informed consent and accessibility. Data fiduciaries must make sure that consent mechanisms are accessible, especially for those with disabilities. Example: if a service provider collects data from individuals with disabilities, it must provide them with accessible consent forms, such as through text-to-speech or Braille, so that individuals fully understand and can give informed consent. Special conditions for processing sensitive data. The DPDP Act requires that sensitive data related to individuals with disabilities, e.g., health information, be processed with extra care. Example: a healthcare provider collecting health data from an individual with disabilities must ensure that the data is processed only for the medical purpose and not for any unrelated uses. Key takeaways for data fiduciaries. Here are the key takeaways for organizations handling data from vulnerable populations under the DPDP Act. Enhanced safeguards. Data fiduciaries must implement extra safeguards when processing data related to vulnerable populations, particularly for children and individuals with disabilities. This includes obtaining explicit parental consent and ensuring that consent mechanisms are accessible. Data minimization and purpose limitation. Ensure that only the minimum amount of data necessary is collected from vulnerable populations and that it is only used for specified and lawful purposes. Strict compliance with parental consent. When processing children's data, organizations must ensure that verifiable parental consent is obtained and no harmful data processing occurs. Prevention of targeted advertising. Vulnerable populations, especially children, should be protected from exploitative practices such as targeted advertising. Ongoing risk assessment. Regularly assess and mitigate risks to the data of vulnerable populations. This includes conducting audits, data protection impact assessments, DPIAs, and ensuring compliance with data protection practices. Conclusion. The DPDP Act establishes a robust framework for protecting the personal data of vulnerable populations, including children, individuals with disabilities, and other marginalized groups. By implementing these provisions, data fiduciaries ensure that the privacy and rights of these groups are respected, safeguarded, and upheld in all data processing activities. Compliance with these provisions is essential to ensure that personal data is processed ethically and responsibly, protecting vulnerable individuals from misuse, exploitation, or harm. In the next chapter, we will explore the penalties for non-compliance under the DPDP Act, focusing on the enforcement mechanisms and the consequences of failing to adhere to data protection requirements. Thank you for joining this session. In the next module, we will explore the future of data protection in India, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.